Call the meeting to order. We have a motion approving the minutes of the last meeting. Motion by Supervisor Molino, second by Devitt. All in favor?
Aye.
Aye, opposed, carried. Okay, first item's resolution and request to approve the bids from the tax foreclosure auction. Lexi, you wanna talk about that?
Sure. They are attached for you all to see, and down below under new business was review of this too, so we can probably kill two birds with one stone. We had an auction that, went over very well. There was two parcels that did not sell. There was one up in Hague on Graphite Mountain Road that was already under the county's name, as well as one on Smith Street in Warrensburg that did not sell. So that's something that we're probably gonna have to look into, seeing what we can do with those properties. They are ones that, we had talked to you about in the spring, I believe it was, and I mailed letters out to everybody at the beginning of September, just to make them aware that there was a neighboring piece in case they were interested, but these two still did not sell. We did have one in Queensbury, that only sold for $1, but it was a little strip of land, and it was being used already by this lady because she thought she owned it. So she came to the auction because I had mailed her the letter, and she actually bought the piece of property. It was of no use to anybody else. It was already fenced in to her property. So, that one did sell, but I'm hoping that you will all support the approval of the attached bids.
What's the, property class code for the residential with
Anything in the 200s
200, okay.
is residential, and the 300s is vacant.
So, like 240, which
A
Which one
210
is occupied, or is
a
the home on it?
single-family residence.
210, okay, so we had quite a few. One, two,
There was a few houses on there this year.
six of them.
Had people with money that came to the office.
Yeah, yep,
And,
I'm surprised that house in Lake Luzerne went for 52.
yeah.
looks like all the ones with
Doesn't look
with
bad.
homes on them
I don't know what the inside.
sold for way more than what the taxes were.
Yes, yeah, because they sell more for what the value of the home is than
Right.
what the taxes are.
Right. And then what's 240, then, is that vacant land? Vacant residential?
No, 240 is the one in New Vermont Road. It's, a larger acreage. It had a single-family residence on it, but, it had like 100 and some odd acres.
Okay.
So it might have been rural residential or something. I'm not 100% off the top of my head.
So it looks like we made $500,000 more than what the taxes were, right?
Yes.
Okay.
Mr. Chairman, I just have a couple of comments when you're,
Okay. Yeah, fine.
with respect to the next steps, obviously looking for the recommendation today, and then I think this goes at the November meeting for the approval of all the sales. You'll recall, this year we've at the request of Mike and Lexi, we put some changes in place where these transactions are gonna be completed in 2014. And I think that's a real good idea, so that the deeds are gonna be conveyed, recorded. The purchasers are going to have their funds into the county, and I think most of this funding should be in by the end of the calendar year. That was the objective that Mike and Lexi had. We're set up at the county attorney's office to do just that. The other thing I wanted to mention is we've developed a form, an early access form, for purchasers, successful purchasers who want to access their purchased properties before the deed gets conveyed, say for example to drain the water pipes. So we've developed a form, I've developed a form, it's signed by Mike. There's one party in particular who came to my office last week and said, you know, I'm a snowbird, and I want to get in there with a plumber, and I want to be able to drain the pipes so we don't have any damage to the structure. So that form has been developed, and it protects the county and yet affords the property owner prospective property owner the opportunity to go in and take protective measures between
Mhm.
now and the time the really cold weather sets in.
Mhm.
We've done that before. We did that last year. Somebody had some issues. They wanted to, cover a roof. They were concerned about the roof. So we work with these folks and, try to help them protect their new assets.
That's if it's not already occupied by the former owner, probably,
Correct.
right? Yeah, okay. You have a motion to approve these, bids then? Motion made by Supervisor Molino, second by Supervisor Beatty. Any discussion? Hearing none, all in favor? Aye. Opposed? Carried. Okay. So, next item,
Pending item is the
Installment
next
agreement.
item, which was the installment agreements that we started to talk about, at last month's meeting, and, we had asked that Mr. Swan be present to be able to, have some input on this.
okay. Just to refresh everybody's memory, the way the tax sales used to go was that, if you were delinquent, you could be 3 years delinquent on residential property and always paying the oldest tax. And then the law was changed. I don't remember how long ago it was, but it must be 95? Okay. Yeah. To change it to where if somebody was doing that, now all of a sudden they'd have to pay three years because you gotta pay the newest one, then the second newest one, then the oldest one. And then in addition to that, I'm not sure when this happened, but maybe Mike knows, they also, said that to change the law to the effect that if you have installment agreements and you have multiple properties, they all have to be in an installment agreement, and you can't do them separately, and you can't decide to save one and let the other one go, or save two and let three go if you have 5 of them. So, I've always felt that was wrong. We opposed it when they did this, and I think we should take a position opposing it now. I think Mike and county attorney might have a different view, so hear from Mike. Yeah. Yeah. Right. Well, no, I mean, I have a long experience of passing resolutions asking the legislature to do something. They don't do it very often. Yeah. Right. Yeah, Peter?
So this is state law, it's not county law.
Right.
Just a quick observation, I mean, if you had a sophisticated property owner, he just wouldn't be structured that way. He just, everything would be separate and
Right.
stand on its own, so
Mhm.
seems to take advantage of people that are not terribly sophisticated, a little bit.
Right. Yeah, you could just put it in, somebody that really knows what they're doing would just put it in separate names. You put one in your wife's name and one in your child's name, and so you can have, so you can save them. But it just seems to me like this last sale, that if a property owner we had that has 5 properties and they're all in one installment agreement, and say they owe $50,000 total, $10,000 for each parcel, and they scrape together and sell everything they possibly can and come up with $40,000, bring $40,000 down to the treasurer's office, and the treasurer is in the position of having to say, no, you're gonna lose all 5 because you can only bail out 4. It doesn't strike me as being fair.
I agree. So
Yes.
what were we going to?
Beatty?
No, I agree with you, Mr.
Yeah,
Chairman,
yeah.
that, I think the sense of fairness there
Yeah.
is not even close to reality, and I would, submit that I would agree with your proposal or motion, if we're gonna have a motion, on changing this.
Mhm.
At least letting them know our feelings.
Okay, would you make it as a motion then?
Yeah, how would you
Okay.
like me to word that?
Well, I mean, two things I'm concerned about. One is having to pay the newest one first, which
Right.
for someone who has been in arrears for a long time, it just make it extremely difficult then for them to save the property. Or someone who has what I call one of the 4 Ds, death, divorce, disability, or downturn in business. that's what usually causes these things. I mean, most people, if they have the means, will pay their taxes because they don't wanna lose their property. So something bad in most of the cases has happened to these families or individuals. And then to just make it harder for them to try to retain their property just doesn't seem to me to be proper. And it's, if you look at what's in the best interest of the county, I think what's in the best interest of the county is to have property owners stay in their property, stay in the ownership of their property, keep their businesses going, keep the home, keep the family home. So what I would suggest is a resolution asking the legislature to consider going back to the old method, which is if you don't pay your taxes for the 3 years or 2 years, then it goes to a tax foreclosure. And if you go into installment agreements, you can have individual installment agreements, and if you can save some of your properties but not all, so be it. So there'd be two changes.
Okay.
Okay. I don't give up.
Exactly what you said is I'd like to propose as a motion.
Okay. Clear as mud, Martin?
Well, I just wanna, I guess I just wanna make sure that, if you're delinquent and you have multiple parcels,
Right.
You can, and you're otherwise in the tax foreclosure proceeding, or would be in the tax foreclosure proceeding, you can, enter into individual installment agreements for each parcel that you
Right.
may own.
Mhm.
And you can, you don't have to have one installment agreement. And you could theoretically default on one of those agreements.
Right.
That parcel would go through the tax foreclosure, and your other agreement that you, maybe were in default of but became current on, you would
Right.
save and wouldn't go into the
Right. That's basically it.
foreclosure sale. And then
Mhm.
the other, issue is that, and you no longer, the recommendation is to modify the legislation which would require someone who is a delinquent taxpayer, no longer require them to paying the most recent delinquent tax first.
Right.
You could go back in time and pay the latter tax
So this one.
and keep you
Mhm.
out of the foreclosure
Yeah.
process that way.
Keep one step ahead of the sheriff.
Okay.
Basically.
Mike, is that?
Yeah. And are they the legislature likely to act on our request? Probably not, but I think it's worth.
Why
Yes,
wouldn't
Dan.
they, Mr. Chairman? Why wouldn't they,
When this passed, it seemed that there was some politically powerful forces in Long Island that pushed this. I didn't hear about anyone up our way being in favor of this.
But if the objective is to keep people paying taxes on their lands
Right.
and go through every means possible to not foreclose
Yeah.
on multiple property owners, I can't see the advantage in going the current law and having the current law in place. I just don't understand why people maybe from Long Island or something would think this is good for.
Well, it seems to me the way they viewed it was they look at what's best for the county, for the county revenues, that maximizes the revenue to the county. The more people that lose their home and the county, like on this first one, on the recent sale, we made $90,000 on that. So the more properties you can sell,
Yeah.
the faster, the more money that comes into the county, and it helps the county's cash flow. But I've always felt that the more important value is keeping people in their properties.
Bear
Mike?
in mind.
Well, the root of this was the fact that there was such a, well, first of all, there was no uniformity how everything was done statewide, okay? So this is what the law did, was to uniform the whole process. Took out things like where if you paid somebody taxes, you could take their property from them,
Mhm.
those type of things were taken out. So this was what that whole bundle did. But in the downstate area, what was happening was, is that because in the nineties, that's when their taxes started to escalate tremendously, people were perpetually behind. And the county was having to foot the bill for those 2 years, because what was happening was, they were only paying the whole district all the time. Every year they pay the oldest. So they were always 2 years delinquent, okay? So the downstaters, having more power than the upstaters do, they got tired of this, and they felt that it was a drain on the county coffers, pushed this legislation through to make it current. Because what that did is, when the law went into effect, that forced everybody to catch up. Because you paid the current, and if you didn't pay that old, 3 years old one, then even though you paid your current one, you could be foreclosed on and lose your property.
Yeah.
So that was the way,
It-
I'm not saying that it's right or wrong, I'm
Yeah,
just trying to give you
no,
an
I
explanation.
appreciate the history.
Yeah.
Yeah,
And
thanks.
so, that was, the whole drive of that was to force those people that were perpetually 2 years behind in taxes to catch up.
All right, but,
Forces the
so
county
it did,
to make
it
everyone
did do
whole.
that. It forced
All the
the ones,
schools, when people don't pay their school taxes,
Well-
the county has to make them whole. When people don't pay their taxes, it's all coming out of the county funds to make everybody whole. So, that's why I think when Mike's saying, like, the downstairs having more power, I think because it was coming back on the county so hard down there, that it was taking so much funds from the county to have to make the towns and the school, everybody whole.
Okay.
yes, yeah.
The city does a thing where if we take a house, because of taxes, I believe it, we sell it, or in some way we transfer it to I think it's the IDA, and then they sell it, and they can pick they can have a preferred buyer and all that sort of thing.
Mm.
I wonder if that might be a solution.
We can't do that because the city operates under a little different, law, portion of the law, I'm not sure exactly how to say this. But because the city is a city and it's got a charter, there are allotted some things in this law, and I'd have to go back and look exactly how it's set up. But I looked into this years ago, and the city can do things a little differently than the rest of us can.
So what Mike said is true, that, the goal was to deal with the people who were gaming the system and always paying 3 years in arrear. But the unfortunate thing is it caught all these other people who have a death in the family and the estate's not settled, or they, you know, the breadwinner becomes disabled, or there's a divorce and they're haggling over, you know, who's gonna pay the taxes, and nobody does. So it catches all those people that have fallen on hard times, and that maybe weren't gaming the system, but just something bad happened to them.
Bad things happen to good people.
Right. So, we got a motion, any seconded by Peter. Any further discussion? If not, all in favor?
Aye.
Opposed, carried. Okay, thank you. Okay, new business, review of the October 18th tax foreclosure
Which
act.
we kinda did with the
Yeah.
resolution at
Right.
the top. But if there's any other questions, I'll gladly answer them.
Okay, any other questions? Okay, if not, on to 5B, which is county attorney and county treasurer to address proposed settlement in Alexi Brothers versus Town of Queensbury, RPTL, Article 7 proceeding. Assume that's not you, Alexi, right?
No.
Okay.
The reason why, Mike and I wanted to talk to the committee about this, today, this is a very long-standing tax assessment challenge, which involved, the town of Queensbury and, Queensbury Union Free School District and Warren County. Warren County typically does not get involved in Article 7 tax assessment challenges. Tax assessment challenge, property owner says, my tax assessment is too high, I've gone through the administrative process at the town has denied my relief, I file what's known as an Article 7, challenging the tax assessment on my property. This started back in 2005, I actually represented the school district for a number of years on these proceedings. And it started back in 2005 as a dual challenge. There were 60-some property owners, all of whom were lakefront property owners, who were initially involved in this challenge. It was a twofold challenge. What do I mean by that? They challenged not only their tax assessments in the Article 7 proceeding, but they essentially filed a hybrid proceeding challenging the town of Queensbury's revaluation in 2005. And that's why the county was named in the proceedings. We usually get notice of the proceedings, we're usually served with the proceedings, and we have an opportunity to intervene if we want to. We typically don't, and I'm not suggesting that we should. But here, we were specifically named in the Article 78 proceeding, brought us into the Article 7 proceeding as well. Through the years, the Queensbury assessors, both Helen Oddie and Terry Ross, have done a phenomenal job of resolving these properties, the vast majority of these properties, through settlement discussions. What's left for your consideration are 3 parcels who remain within the Article 7 tax assessment proceedings. The challenge to the Queensbury's revaluation is done. That's over. That's not part of this process. And there was no relief granted there. But these Article 7 proceedings remain outstanding. 3 properties remain. Mary Beth Young, 9 Fielding Lane, Richard Young, 47 Assembly Point Road, and John Brothers, 12 Tall Timbers Road. Both the Queensbury School District and the town of Queensbury have agreed to a settlement in these proceedings. Again, we would not typically have to take this up for your consideration, but because we are a named party, we have to. As with many cases, although, not many, but as with a number of cases, sometimes there is relief granted which results in refunds, tax refunds. That is the case here, and I think the parties, the respondents, namely the town, the school district, and the county, have done a very good job of trying to, limit the exposure to refunds. But our exposure in this is a total, for all 3 parcels, for all the years at issue, dating back to 2005, of $11,777.12. I have kept Mike Swan closely advised on these proceedings, and I think we've done the best that we can do. Again, the school district and the town have already passed resolutions approving this settlement. The school district had a refund of $23,500 and change, and the town's portion was a little over $5,204.11. So what I'm asking, and what I'm asking on behalf of Mike, is a resolution authorizing the county attorney to execute a stipulation of settlement which would bring these cases to closure. The assessor has already agreed on the assessments going forward for the next couple of years. I think we have to defer to her on that issue. There have been appraisals done on these properties. She's examined those appraisals. She's critiqued those appraisals. And I feel very comfortable with her knowledge as to what she thinks these values should be going forward. And obviously there's a reduction in these assessments. So with that, Mr. Chairman, I'm certainly willing to try to answer any questions that you or the committee may have, but that's what we're looking for.
So we have motions from the committee to approve this, and we can discuss it further. Motion by Supervisor Beatty, seconded by Supervisor McDevitt. Discussion. Questions?
My question is, what is the new assessments? Because going forward, if they've been lowered, obviously that will affect also our tax, the tax liability and so forth.
True, but remember that through the years, there were 60-some parcels, all of which were adjusted, all of which have been, for the most part, adjusted downward. There are slight adjustments downward. These are not enormous changes. There's, 50,000 here, 100,000 there, but these are all parcels and properties that, in the grand scheme of things, are, worth $1 million or more. While there's certainly a reduction going forward, I think the assessor has looked carefully at these and is very comfortable with those numbers going forward. And I don't think, Doug, we really have a say in that. I don't think I don't think we have standing to hold up a settlement based upon the assessor's formulation for an assessment.
Just
Thanks.
another question, was the school specifically named also? Because typically the school doesn't get involved either, right?
The school was specifically named, and in Queensbury, and in Lake George, and in a number of other school districts, those school districts do actively participate in Article 7 proceedings. I know that, from my own personal experience, because I used to represent them.
I didn't realize that, because in Chester, you know, we had a big challenge by Word of Life, it involved tens of millions of dollars of assessed value.
Well, I always took the position as counsel for the school districts that, look, you know, you have the biggest exposure here.
Got the biggest stake, definitely.
And,
Right.
this is a big source of your refund, and you need to share in the expenses, and I always thought that the school districts benefited by having counsel involved
Right.
and, got better results.
Yeah. Yeah, I mean, you just look at this one, it's 23,000 for the school, 11,000 for the county, and only 5,000 for the town, which, you know, otherwise would bear the brunt of the whole litigation.
Correct.
So, okay, any further discussion? Hearing none, all in favor? Aye, opposed? Excuse me? The funding for it? Okay.
Where would this funding come from,
Gonna
Mike?
have to refer it to finance, I believe, right?
Yeah, this would be under the legal settlement stuff, which basically is gonna come out of the general fund, I mean, that's the only place.
Okay, so we'd have to refer it to finance, okay.
We can work that out at
Yeah.
finance.
So could we, include, referring this to, finance then, in the motion in a second?
That's a good idea, so we make sure we've got the funding line.
Right. Okay. So who made the motions? So was it Beatty? Can we include referring it to finance in your motion?
Yes.
Second, okay, all in favor?
Aye.
Aye, opposed, carried.
Thank you.
Okay.
I appreciate the discussion on that, and then
Mhm.
I have just one other item, as you know, Mr.
Right.
Chairman, that I wanted to talk to the committee about.
Mhm.
It's not, typical, that we see requests from other counties, but there's a request from Wayne County, that's come across through NISAC that I wanted to talk to the committee about. Wayne County finds itself in a very precarious position. Wayne County, like Warren County, utilizes the Article 11 IM-REM tax proceeding process, every year, just like we do. In Wayne County, there was a taxpayer, who had unpaid taxes, $7,292 in unpaid taxes, and entered into an installment payment agreement, defaulted in that agreement. And then what happened was the county went through the foreclosure and auction process, and, sold the property at an auction, to a new owner, new buyer. The former owner then filed a proceeding in bankruptcy, and through their bankruptcy counsel, maintained that the sale at the auction was a fraudulent transfer under Section 548 of the Bankruptcy Code within 24 months of the filing of the bankruptcy, because the property did not sell at the auction for fair market value. They commenced in what's known as an adversary proceeding in bankruptcy courts pending in the Western District of New York out by Buffalo. And so far they've been very successful. The former property owner has been very successful. Wayne County is defending this action. Wayne County is at substantial risk here. One of the things that I didn't tell you that I should have told you is that the new owner made improvements to the property. Substantial improvements to the property, I'm told. The bankruptcy court judge is, I think, trying to resolve the case for the litigants, as often happens. But they find themselves in a very precarious position, because Wayne County is being looked at for damages here in the context of the tax foreclosure auction. The numbers are pretty significant. The fair market value of the property has been indicated at $49,000, which is well above the $4,000 received at auction. Wayne County might be out that expense. There might be other expenses that Wayne County might be out of. But so far, the bankruptcy court has seemed to agreed, or at least ruled, that this constitutes a transfer for less than fair market value within the 2-year period under Section 548 of the Bankruptcy Code. As you can imagine, where I'm going with this is that This has implications, potential implications for Warren County.
Sure.
It has implications for all the other counties in New York State that utilize the Article 11 process. And yes, perhaps there's a legislative fix out there, but there is not a lot of hope for a legislative fix, at least in the immediate future. In defending this proceeding, Wayne County has spent over $150,000 in attorney's fees so far. They're out of money, and they have made a call through NISAC to all the counties around the state for financial assistance. They're asking for $2,000 from each county. Yesterday, I spoke to Dan Connors, who's the county attorney in Wayne County. They've had a good response to this so far. A number of counties have committed to financial support. A number of counties are in the "we're interested" category. Based upon my conversation with the chair and with Mike and with Lexi, I put us in the interested category, subject to your consideration and to board approval. I do think this is something that if there is a loss, if Wayne County loses this case, I think it does have, possibly, serious implications for us as we go forward, and puts us at risk going forward. Again, I think there needs to be a legislative fix at the federal level. Getting that might be difficult. Maybe a legislative fix at the state level, but then you have the federal question issue, supremacy issue that's at play, and so I think the best course of action for Wayne to take at this point is to continue fighting this thing. That's their intention, but they're looking for our support. And again, a number of counties have indicated they're interested. A number of counties have already committed. I did speak to the Washington County attorney. I thought maybe some of the members here might want to know what Washington's position is. As you know, Washington County has been through that legal debate, legal issue with the public defenders, and the recent outcome of that. And I don't think that they're in a position to lend financial support at this time. I would typically reach out to Saratoga County attorney. I haven't done that yet. But I thought, Mr. Chairman, we would just bring this up for your consideration here today to see what the reaction is. And obviously, I wouldn't be doing this unless I thought it was a good idea.
Did they, I don't recall, did they ask for a specific amount?
$2,000.
2,000, that's what I was thinking, okay. Okay, I think we should seriously consider this because, I mean, it would create a principle that an auction ordered by a state court is fraudulent transfer under the bankruptcy court. And I just think that could have huge implications for us. For example, in the sale on October 18th, we received more than $510,000 more than what the unpaid taxes were. And so it seems like, that's the amount that could be at stake just this year. So I think we should support it. I don't know if, Martin, if you had a chance to look into the legal aspects of assisting another county with their litigation, but where it's going to impact Warren County if there's a loss.
I spoke to, that's one of the questions I had for Dan Connors when I spoke to him, and as you know, Chair, I mean, that's been a concern of mine since the first day we talked about this. The theory is that, again, this has far-reaching impacts to counties throughout New York State and could put us in substantial risk if this case is lost. We think that as a result of that, county attorneys feel that that is the sort of consideration, if you will, for making this contribution. Contribution, by the way, would not go to Wayne County. It would go to NISAC, and NISAC would distribute the funds. So I think that's also a level of protection as well. They're setting up a source, a fund, if you will, to do this. So I'm not, I think when you put it in the balance, the risk of being challenged for not having the authority to do it versus the risk of an adverse outcome and the long-term benefits of that to the county, I think I would side with the long-term benefits of making the contribution. I do think there is legal authority to do this. Might be a case of first impression, but I think the county is not without argument for reaching a rational decision, if you will, to make that contribution to this fight. I would also mention that NISAC has set up a committee to explore, legislative resolutions to this. I asked Dan Connors where that is, as the case may be, and Dan had indicated that they didn't think that, given the climate in Washington, that there was much of a likelihood that there would be a modification to the bankruptcy code anytime soon. I just wanted to emphasize, when I say fraudulent transfer, nobody is saying that fraud was involved.
Right.
Fraudulent transfer defined in the bankruptcy code means it was sold for less than fair market value
Right.
within that 24-month period.
Sure.
That's why it's being deemed
Yeah.
by the courts a fraudulent transfer.
Right, and we have a number of properties in the October 18th tax sale, which were sold for, less than their fair market value.
And it
But
would...
the point is, it's done by court order.
That's right, and it would seem to me that a courts do this all the time. A court could say, we've looked at the legislative history of Section 548 of the Bankruptcy Code, we've considered this, and we don't think a state court-ordered auction or sale at an auction it fits within the definition of a fraudulent conveyance within 548. It would be very easy for a court to make that determination. But here, so far, they haven't made that determination.
Right, and the legislative fix would just be to exempt, court-ordered auctions.
Correct.
from tax sales. So, yes, Mike?
I would just like to throw my support into this. You know, I've talked with a lot of the treasurers from around the state, and the potential this could be devastating to the counties. We could get some of these overturned. So I would just like to, say that as much as I don't like spending money, as long as we can legally do this through NISAC, I think it's the right thing to do.
Okay, so we have a motion to approve. Motion by Supervisor Molino, second by Supervisor McDevitt. Any further discussion? Yeah. Okay, again, we need the source of funding, so could we include referral to the Finance Committee for the source of funding? Okay, any further discussion? Hearing none, all in favor?
Aye.
Aye, opposed, carried.
Thank you.
That's it? Okay, thank you. Okay, motion to adjourn? Made, seconded, all in favor?
Aye.